Hello, everyone, and welcome to week one. And this week we focus more about the law on torts. And this module, this video, will provide an introduction to torts. For those of you who've watched the first video that I prepared, which provided an overview of torts and our torts unit, I had talked about the importance of torts and torts law in society, particularly that tortious liability has in fact become a source of a lot of litigation that occurs in Australia. And you will recall, it is mainly because in Australia, for example, or anywhere in the world for that matter, there are a lot of personal injuries that occur on a daily basis. So you can have personal injuries as a result of a road accident injury. It could be a work-related injury. It might involve a slip and fall injury, like as I mentioned, you could have somebody walking along a pathway and that person slips, and there might the legal question that arises is whether or not there is a legal liability on the basis of torts on the part of perhaps the local council who has the obligation to maintain the pathway, or whether or not there is a legal liability on the part of the owner of that pathway, if that is the case. We also know that a lot of medical negligence cases happen. It could be an example. A typical example might be that you have somebody there who came for surgery, and the purpose perhaps was to have an appendix removed, and in the process, out of a mistake, what was removed instead was perhaps a liver or a kidney. That's certainly medical negligence. You can also have instances where somebody or a patient approaches a specialist asking for medical advice. And it might be that on the basis of limited advice that was given by a medical specialist, a person may decide to undertake surgery or not undertake surgery, and as a result suffers harm. And if there were evidence of negligence on the part of the medical specialist, that can lead to a tort. There will also be instances of public liability where there might be an obligation on the part of a public entity to, for example, make sure that certain areas, public areas, are well maintained. It could be in the form of rivers, or it can be the form of the esplanade. It might be in the lagoons that local councils may have. And if, as a result of an injury that occurs to certain members of the public in those public areas, it might lead to liability on the part of a public entity, whether it's a local council or even a state government, such as a failure, for example, on the part of the Queensland state to make sure that some roads are roadworthy, and as a result, there might be certain road accidents or injuries. There will also be occupational diseases. Some of these may be because of falls from at work, but it might be as simple as you having a worker, for example, who works at Coles or at Woolies, where there are strict instructions on the part of the employer that there are limits to what a person is meant to carry or to lift. But as a result, an employee suffers injury, maybe a back injury, and so on. And that is in the nature. Now, that's an occupational injury, but there might be instances where an employee might be exposed to harmful chemicals or harmful dust. And in that case, that might lead to a disease, such as a lung disease. Or it might be exposure to certain bacteria as a result of somebody working in a laboratory setting. And the question then arises, is there a legal obligation on the part of the employer? You will also be you might also come across instances of what is known as asbestos injury as a result of what happened in the 1970s, where it wasn't then known that being exposed to asbestos can lead to a certain form of cancer, and that can lead to tortious liability. And I also mentioned that you can have an obligation on the basis of tort for abuse, such as physical abuse or sexual abuse, and we've seen that happen. Unfortunately, in recent years, on the basis of government reports and royal commissions, where certain organizations, especially churches and church-based groups, have been responsible for both physical and sexual abuse. And in all of these cases where there was harm suffered by an individual on the basis of an act or omission of another individual, that can lead to a civil wrong and an action for damages on the part of a certain individual. But as I noted, when you speak of tort, and although I said that it is mainly personal injuries which often becomes the basis for a tortious liability, you can also have torts on the basis of an economic loss, such as a wrong advice given by a lawyer, for example, to his client, which means that perhaps, for example, if a client sustained personal injuries as a result of a vehicular accident, there is a limitation of that action. The action must be filed or must be commenced within a period of 3 years under the Limitations Act 1974, Queensland. And if the solicitor fails to properly provide advice, and as a result, the action for personal injuries can no longer be filed because of the Limitation of Actions Act of 1974 Queensland, and that leads to loss on the part of the injured individual, injured as a result of a vehicular accident or personal injury, then that leads to an economic loss. And that individual then can proceed against the lawyer who provided wrong advice. You'd also see the case of Hadley Byrne, where there might be wrong advice provided by a financial advisor. And if as a result of that wrong advice that leads to damage or injury or harm to an individual who was hoping to receive reasonable or proper advice, and that leads to economic loss, then torts would have been committed by the financial advisor. You can also have torts on the basis of nuisance, trespass to land, intentional torts relating to goods, defamation, economic torts, and unfair business practices. These are things which we're mainly covering, except I think trespass to land. But the point of me highlighting these instances where there can be a tortious liability is the fact that the possibility of tort and the possibility for tortious liability is all around us every day. And which highlights, therefore, the importance of knowing about tort law. And so today, our goal in this particular video is for me to be able to provide an introduction to you about torts, what it is as a concept, and so on. So at the end of this module, you should be able to understand the essence of tort law as a branch of the law of civil obligations, explain the differences between tort, contract, and criminal law, explain in general terms the basic elements of tortious liability, and explain the aims of tort law within the theoretical frameworks discussed. Now, again, as a reminder, this is only an introduction. If you struggle initially in trying to wrap your mind around the concept of tort or tort law, don't worry too much, because we still have about 12 weeks to go. And across the 12 weeks, we begin to unpack tort law and torts in greater detail, and you will become more familiar and will be in a better position to understand what torts and torts law are all about in the succeeding weeks. Okay, so having done that, in terms of the outline, I'm going to be talking about what is tort, the evolution of tort. Do you pronounce it as tort or tort? Okay, anyway, pardon my American English, so I'll pronounce it as tort. We'll talk about the common law, judges and statute, characteristics of tortious liability, relationship of tort law to other areas of law, and the aims of tort law. So that's going to be the outline of my lecture today. So what exactly is tort law and what exactly is tort? So we begin by looking at the idea of tort, which is actually a French term for a wrong. And so tort law, therefore, encompasses all those instances where there is a collection of wrongs, and as a result, the law provides remedies for somebody who suffers harm or injury as a result of a wrong. And what it essentially also means is that based on tort law, each individual wrong is to be resolved between the parties involved. So uh, even though there is no contractual undertaking between parties, even though two parties may not have an agreement that if there is wrong that is suffered by one, then there is a legal redress towards damages. Tort law imposes a legal obligation upon any individual who by act or omission causes harm to another, especially in those circumstances where there might be a duty of care or there might be a duty as imposed by law, especially when the act or omission of who we call the wrongdoer or the tortfeasor infringes on certain rights recognized by the law. So when we examine tortuous actions, therefore, it has some common features. There is an act or omission. That act or omission infringes on a legally recognized right, and then it gives rise to an action for damages. So take note that if there is an act or omission which infringes on a legally recognized right, it becomes part of tort law only if the action leads to an action for damages, because an act or omission of an individual which can infringe a legally recognized right can in fact be lead to criminal action. And we're going to make a distinction between tort law as opposed to criminal law in a short while. But it only becomes the act or omission that causes harm or injury or damage based on the fact that there is an infringement of a legally recognized right, becomes part of tort law only when it gives rise to an action for damages, but not when that act or omission leads to criminal liability. Okay, so what typically happens is that if there is a tortuous conduct or act or omission that leads to harm, the action that arises, the legal action that an injured person can then have will be an action for damages. We should also note that especially as we move on in this unit, we will also note that the notion of tort oftentimes is not easily defined, because although we often say that it is an act or omission that causes harm to an individual, one of the basic elements for there to be a tort or for there to be tortuous liability is the need to establish causation, so that even though there is an act or omission, as we see later on, and even though that act or omission may lead to harm or injury, and that is harm or injury based on the infringement of a legally recognized right, for the victim or individual who suffered the harm or injury to be able to seek damages from the tortfeasor or the wrongdoer, there is a legal requirement to prove causation. So it must be proven that it was the act or omission that actually led to the harm. In other words, but for the act or omission of a tortfeasor, the harm wouldn't have occurred or wouldn't have eventuated upon an injured individual. Now, that sometimes becomes problematic, mainly because there will be instances when there is such a thing as the notion of strict liability. It is possible that that an individual, for example, may undertake certain activities where you can't really say that there was negligence or there was an intentional act to cause harm, but as a result, still, on the basis of strict liability, somebody, if he causes harm, will still be held liable. So, for example, one of the cases we will examine will be an instance where somebody may have a haystack, and assuming that the purpose of the haystack is really to just make sure that the hay is dry and so on. But what if, out of no fault on the part of the individual or the owner of the land, the hay catches fire, and when it does, it spreads across other properties? You can't really say, what if you can't really prove negligence because he wasn't being negligent? And certainly you can't prove intention. The question then, was that a tortuous act? And we will notice that in those instances, the law will still impose a legal obligation on the part of the tortfeasor or the wrongdoer, a legal liability to pay damages to the harm that was suffered by another individual on the basis of strict liability. Another example might be you might be riding a plane, or you might enjoy uh, riding on a hot air balloon. And what if in riding on an airplane or a jet plane or on a hot air balloon, there is a lightning that strikes it, and as a result, the plane crashes, or that hot air balloon catches fire. Okay, certainly, because it is what is known in contract law as a force majeure or fortuitous event or an act of God. It's very difficult to say. You can't. It's difficult to establish, or impossible to establish, negligence on the part of the pilot or the airline carrier, because he wasn't negligent it wasn't negligence that led to the crash. It was an act of God. But in that particular case, there will be tortious liability, because in that scenario there will be strict liability, regardless of the actions or inactions of a common carrier or an airline. There will still be liability imposed by the law, by the common law, on the aircraft owner as a result of harm suffered by a passenger. Okay, so when you go through the textbooks, for example, on tort law, you will notice a lot of authors admitting and acknowledging the difficulty in trying to establish a common basis for tort. Is it on the basis of negligence? Is it on the basis of intention? Is it on the basis of strict liability? And at the end of the day, they will simply say that it is a tort because the law says it is a civil wrong, which must lead to an action for damages. So in other words, it's a bit circular, but you will still have a sense of what a tort is, because you know that there is an act or omission, that there has been harm suffered by an individual or an injury suffered by an individual as a result of an act or omission infringing a legally recognized right. Okay, so let's move on. Now, what is tort law, which I previously discussed, and what are the types of interests protected by tort law? The examples I gave earlier, I talked about personal injuries, but it's not just about personal injuries. You can have, economic loss and so on. But if you examine closely the type of interests protected by tort law, it would be the rights of personal safety and integrity. It would be rights associated with the possession and ownership of land and of personal property, rights associated with economic and commercial interests, and personal reputation. So these are the rights that are generally recognized by the law, so that if an individual by his acts or omissions infringe on those legally recognized rights which lead to harm or injury, then tort law will apply, which means that it will generate a right to claim damages on the part of the victim or the injured individual. Let's examine the evolution of tort law, because this is a good way for us to understand what tort law is all about. If we examine tort law, we will notice that much of tort law evolved from in the UK, in the United Kingdom, or in England at that time, in the 13th century. That is important, because you will notice that when you examine a lot of cases that underpin tort law, a lot of it comes from English courts or courts in the UK. And that is because tort law, in terms of historical origin, has developed and evolved from the UK, or from the English courts or the common law in the UK. But at the start, when tort law evolved, it essentially concerned property and feudal rights. And oftentimes there was a violent interference to property. And if you recall, if you examine the feudal system in the 13th century, where there was a master who owned the land, and you've got vassals or people working for him, not in the context of employee, but essentially an almost absolute control. And during that time, there were no guns, but there were swords and whatever primitive weapons you had. Oftentimes, people would fight over property, and so therefore, there was a need, therefore, for the common law courts or the judges to evolve a system whereby when there was violent interference with the property rights or the feudal rights of the feudal lords or property owners, there had to be a legal source for which the feudal owners or property owners could seek protection. And that was through tort law. So that, during that time, if an individual, through violent, not an omission, but through violent intentional interference with the property rights or feudal rights of an individual, the common law courts would step in to assert or to determine that when the feudal owner or the property owner suffered harm to his property, then he had the right to compensation and to damages. But what it suggests is that a common feature during the time was direct interference. There was an intentionality in the actions of an individual. Through time, it was also recognized, however, that there would be certain types of action that there would be interference, but they would be less violent, they would be less obvious or direct. And these became known as actions of the case. And there could be harm suffered by an individual, not because somebody purposely or deliberately or intentionally sought to cause harm, but because of negligence or in the form of nuisance, somebody got hurt. So negligence is easy to understand. When you talk of negligence, for example, during that time, it might be that the careless actions of an individual when playing around with a sword, when he moved his sword that way, he might end up cutting off the ear of a friend or something, or maybe playing with a bow and arrow. In the case of Robin Hood, if you know Robin Hood, and while he was practicing with his arrow, it went through an open path and ended up striking the neck of a neighbor, or maybe the cow of a neighbor. And the question is, there was no intention to cause harm, but the action certainly could be considered negligent. And in that case, tort law had to step in to say that, the individual who suffered harm should be compensated for the damages. There are many ways that you can examine nuisance. Nuisance can occur where the property of an individual can lead to harm to another person, for example. It might be smoke, it might be chemicals, it might be that, it might be that in your garden, you see a lot of weeds and you use a poison killer. Is that correct? Or a weed killer. But it happens that the weed killer ends up killing the roses of your neighbor. That, in that case, that can be considered nuisance. So you'll notice, therefore, that tort law evolved from those points where there was violent interference, and later on, instead of being violent, there were just some intentionality in the actions of a tortfeasor, which led to harm. But slowly, the courts recognized that there had to be a law that protected individuals from harm or injury as a result of negligence or the nuisance of neighbors. Now, one of the most dominant and more important cases we need to recognize and remember in tort law is the case of Donoghue versus Stevenson. Because one of the things we need to remember is that and I'll talk more about civil law contracts in a short while, what we need to remember is that typically for there to be a legal obligation on the part of a party, it is on the basis of an agreement covered by contract law. So if there are voluntary undertakings or commitments and promises between two parties on the basis of contract law, they will be bound by those contractual obligations. And because in that particular case, in that scenario, both are bound by the contract and there is a privity of contract between them. They were the ones who entered into a contract. But what happens in a situation such as the case of Donoghue versus Stevenson, where you bring along a friend, you go to a, how do you call it, an ale bar or a bar, and you go for drinks, and they say, okay, it's going to be my shout, I'll buy you the drink, or I'll buy you, in that case, the ginger ale. So in that case, if your friend ends up drinking the ginger ale, there is no contract, privity of contract between your friend and the bar owner, because the contract is actually between the bar owner and you as the one who bought the ginger ale. So now what if your friend for whom you bought the ginger ale suffers harm? In this case, the harm was that when the friend drank the ginger ale, it turns out that there was a dead snail inside the bottle. And he couldn't really see it because it was a colored bottle. I think that's the way it's done with beer, right? To protect it. And so, he suffered harm, as you can imagine, drinking beer, and it turns out that there is a dead snail in it. And of course, during that time, there was no such thing as an Australian consumer law, which I'll talk about briefly in a short while. So the question is, how can that friend who doesn't have a privity of contract with the bar owner sue for damages or claim for damages on the basis of the injury or harm that was suffered? And Lord Atkin, in the case of Donoghue versus Stevenson, said that although contract law does not apply, tort law will apply, because the law will impose an obligation on an individual whose acts or omissions may lead to harm to another when that individual has certain legally recognized rights, and that will lead to a civil action for damages. So that is, one of the most important cases in tort law. The case of Donoghue versus Stevenson. He talked about the neighbor principle. The neighbor principle being that whoever is my neighbor, I have a legal obligation to make sure that my actions do not harm him. Now, we're not at this point going to talk about the neighbor principle, because it leaves a lot of questions. Who exactly is my neighbor? Okay, so for now, we're not going to discuss that, because that becomes a more important concept when we dig further into the concept of negligence in the next module. Okay, so I highlighted the fact that as far as tort law was concerned, it evolved on the basis of the common law. Now, I understand that this is LAWS11069. It's a first-year unit, and some of you, or many of you, might be unfamiliar with what the common law is. For some of you who've taken up constitutional law, you would have gotten the idea that in a traditionally democratic government, you would have three branches of government. You've got the executive, in our case, in Australia, you've got the prime minister and his cabinet. You then have the judges, the judiciary who interpret the law, but the body, the branch of government that legislates or passes laws, that would actually be the parliament or the legislature. Now, if that is the case, how would it be that you hear of the common law, or what is known as the judge-made law? If you go back historically again, in 13th century England or in the UK, especially in what is known as the Orange Revolution, we recall historically in the UK that the judges, the common law courts, asserted their rights to be able to determine what the law was in trying to control the excesses of the monarch. And in doing so, it became recognized that the judges could end up determining what the law was, and if there was actually a gray area in the law, a lacuna in the law, in the sense that the UK Parliament at that point, or the monarch, had failed to pass a law about a certain subject, that area of law, the courts will not refrain from their legal obligation or from their duty to determine what the law is by saying that this is the law. So in other words, even if there is nothing in the statute books that says what the law ought to be, that will not prevent the courts, the common law courts, from saying this is what the law is. So in other words, in that case, that is what is known as the common law, because it came from the common law courts. The courts were common because there was an attempt for laws to be uniform across the different court system in the UK, as opposed to what we might know to be the civil law jurisdiction, where the basis of the law is actually what can be found in the books or in the statute books. And the courts, the judges, look at what is in the law books, in the statute books, to determine what the law is. In the common law system, the judges say what the law is. In fact, the evolution of contract law, the evolution of tort law, and to a great extent, criminal law, is based on the common law. You don't just look at the statute books or the laws passed by the parliament or the legislature to determine what the law is. You look at the decisions of judges. Now, we need to recognize as well that in Australia, just the UK and New Zealand, we are all part of the common law system, or what is known as judge-made law. Now, until the 1980s, there was a doctrine of strict legalism, which applied to most of the common law world. What it essentially meant was that the judges, the common law judges or the common law courts, knowing that they had a legal obligation, they had a legal duty to determine what the law was, then they had to apply how the law, how they understood the law to be, regardless of whatever the consequences might be. Because to the judges, it wasn't their job to examine policy. They didn't have to examine economic or political policy or social policy or the impact on society. Their duty, as they understood it, based on strict legalism, was that they will define and determine the law strictly, because that's simply the job of the judiciary. But as we will later on know, the common law can be very rigid. It can be very inflexible because of strict legalism. Even if it leads to injustice, even if it leads to unfairness, that is what the law is, and that is what the judges will apply. If you examine the notion of negligence, for example, which we examined in week 2, there was a time where if there was a tort on the basis of negligence, it was an all or nothing thing. So it was either the offender was the tortfeasor or wrongdoer was culpable and because of a negligent action or remission, or he was not. If he was not culpable, in other words, if his act or remission did not cause the harm, then the victim got nothing. It was an all or nothing thing. Or what if the injured party contributed to the harm because maybe the injured party was intoxicated, maybe from drinking, from alcoholic drinks, or from drugs? What then? So under the common law, then following strict legalism, if there was contributory negligence on the part of the victim, then there was no legal liability. So that led, in a sense, to some great injustice. Think about that for the moment, because we're going to go talk about tort law on the basis of statutory law in a short while. So part of the doctrine of strict legalism is also related to the notion of legal formalism or declaratory theory of law. So that under this approach, judges are the depositories of the law. The duty of a judge, in a sense, is not really to make law, but it is simply to declare what the law is. So in a sense, you might say that under the common law system, judges make the law. And a way of looking at it is that, no, the judges don't make law. They're simply declaring what the law is. Of course, you really wonder if that is true, because, how do we know where the law is? Even if you trace back historically, through centuries of what the law is by looking at the law books, based on decisions by judges, where did they come from? And we will notice that although in a sense, as far as legal formalism is, the law, the duty of the judge is simply to declare what the law is. Actually, a lot of it has to do with judges saying, this is what the law is because this is what we think the law to be. They're not just declaring what the law is in the sense that they're searching for the law books, but they actually make real law. And that leads to that other point about judicial activism. Remember that when you talk about strict legalism, it leads to the idea that judges strictly apply the law regardless of political, social, and economic conditions. That is not their job. Their job, the duty of judges, is simply to determine what the law is. But what if the application of the law leads to certain social, political, and economic inequalities or injustice? Shouldn't judges consider those as well? And there is, and oftentimes we do see instances of what might be considered to be judicial activism, in the sense that you might think that in that case, judges, in a particular case, you might say that the judge is no longer applying legal standards, but applying, using policy that informs his or her decision. In that sense, there would be judicial activism. The case of Donoghue versus Stevenson, for example, because it is a landmark judicial decision, might be said to reflect judicial activism, in the sense that instead of applying strict legalism and saying that no, the one who suffered harm on the basis of a ginger ale bought by a friend, the common law judges could simply have said, no, he has no recourse, because if you follow strict legalism, there was no privity of contract law does not apply, therefore that friend of yours cannot sue for damages. But as a result of, in a sense, judicial activism, Lord Atkins said, on the basis of tort law, on the basis of negligence, that individual who suffered harm can sue the bar owner. So that is, the common law and the role of judges. But as I mentioned, if you examine under constitutional law, if you examine the three branches of government, it is actually the legislature, which in Australia at the federal level, it is the Common of Parliament. At the level of the states, it would, for example, be the Queensland Parliament. It is actually the parliaments or the legislatures which make the law. They create the law. It isn't the judges who do it. And as far, therefore, as tort law is concerned, because as I mentioned, oftentimes strict legalism can lead to certain injustices, like all or nothing. And there have been certain reforms which have happened to tort law on the basis of laws passed by the parliaments, whether at the level of the states or the Common of Parliament. And the areas, for example, there has been statutory influence relate, for example, to workers' compensation, Australian consumer law. You have the Civil Liability Acts, particularly in Queensland, you have the Civil Liability Act of 2003, Queensland. You can also have industrial safety legislation. So what these statutes have done is to impose certain legal obligations, which cannot be found in the common law. There has also been much of these reforms, for example, in relation to negligence, were a result of the Ip report, which involved Justice Ip and Professor Peter Kane, where they reviewed the law of negligence, and these led to much of the legislative reforms of 2002 and 2003. A lot of these have to do, for example, with the issues of contributory negligence, which we examined, I think, in week 9, where it's no longer all or nothing, but when the actions of an injured individual contribute to the harm that befell him, then courts applying, for example, the Civil Liability Act will have to mitigate or reduce the amount of damages that a particular victim or injured person can receive. So that's an example. There will be issues as well about the level of evidence pertaining to causation that has to be proven. So these are some of the reforms that occurred, especially during the period of 2002 and 2003 as a result of the IP report. And the point about this is that to a great extent, the parliament, both at the federal level and the state level, realized that you couldn't leave it to the judges to determine what the law on torts ought to be. Because if judges, for one, follow strict legalism, in other words, if you, as I said, if it's strict legalism, judges disregard issues of national policy, issues of political and social policy or economic policy. Their focus is really what they think ought to be the law, even if it leads to injustice. But sometimes the parliaments or the legislators feel that the act, it's insufficient, it's just too unjust. They have got to step in, and that's where the parliament steps in to create the law. Not only because it's not really the job of judges to temper their decisions according to the demands of society, because society changes, or according to certain norms. That is the job of parliament. So that's where the role of statute is. Now, crucially here, although in a sense we said that as far as the common is concerned, it's judge-made law, because we know that it is actually the parliament as a third branch of government that creates law or makes law. The net effect is that if the parliament passes a law and that law is inconsistent with the common law will have to be overridden or displaced. So in case of an inconsistency, it is statutory law which will prevail. That is the basic framework, even in the common law system. In fact, if you were to examine Australian constitutional law at the level of the states, for example, it would be impermissible for a state court to declare an act of parliament to be invalid, unless because of the principle of statute, because of the principle of parliamentary supremacy, unless the act of parliament or the law passed by the parliament, the state parliament, contravenes the Australian Commonwealth Constitution. Okay, now moving on. So when you examine tort, therefore, as far as the key features are concerned, we assume that there is a tort because it arises from a breach of duty that is primarily fixed by law. When they say fixed by law, it can be based on the common law or statute, or in other words, law passed by the Commonwealth of Parliament, or what is known as positive law. But more importantly, much of tort law is actually based on the principle of fault. So when there is fault that causes harm or injury, then the one who is at fault should be made to compensate an injured individual. So you have the notion of fault. Fault can be a question of intentionality, meaning an individual intended to harm another, or it could be on the basis of negligence. But it can also be, as I mentioned, the idea of strict liability. In all of these cases, there will be elements of fault. But if there is fault, it has to be because of an act or omission. But not only must there be a fault based on an act or omission, which causes harm, but the harm must involve an infringement of certain rights. So in other words, if there is no legally protected right of an individual who suffers harm, then there is no tortious liability. So for example, in my garden, what if I have a trap there, put it, or maybe I put poison. The purpose of the poison is to kill rats that might be in my backyard or my garden, but that's not really the case. I don't have any rats there, but let's just assume I put poison there because I don't like rats and I want to kill the rats, whatever. Now, as it happens, it may be that there is a neighbor's cat who comes to my property and ends up eating the poison. The question is, did I commit tort? Do I have a tortious obligation? So, well, the question is, number one, was I at fault? Was I negligent perhaps. I certainly had an act or omission, but the question is, did I infringe certain rights? And that which leads us to the question of who is my neighbor. So that's something for you to think about, okay? In that scenario, it is arguable that there is no tort, because I don't owe a legal obligation on the part of my neighbor that I cannot put poison there to kill a rat. Now, if his cat goes there and the cat ends up eating my rat poison, I'm not really at fault because I haven't infringed any of his rights. It will be different though, is that if I had rat poison there, and then I invited the neighbor's children or invited some friends, and the kids, while they were playing in the garden, they saw the rat poison and it looks like a lolly and they like to eat it. In that case, I would likely be at fault because there are certain rights. I would have had a legal obligation to ensure that, when I invite kids to my house or my garden, they don't suffer any injury as a result of my actions or omissions. Okay, so when we examine the idea of tortious liability, for example, and when we look at the notion of fault, how do we know that there is fault? Whose viewpoint is that? So do we examine fault on the basis of the tortfeasor or the wrongdoer? So meaning, when you look at this person, he is of this age, he is of this sex, he comes from this ethnic background, then therefore, this is the standard that we would expect of him when he acts. Or do we look at it from the viewpoint of the victim who suffered harm? In other words, the subjective elements. We will notice that much of tort law, at least from the viewpoint of the law on negligence, focuses on the reasonable or reasonable persons. And oftentimes the statement is the reasonable man. So it's a man, and a he. Okay. And that's why, as we see later on, there's the issue of the feminist theory of law, where why is it a man? Why not the reasonable person? So there is now a move towards a reasonable person as opposed to be the reasonable man. But if you'll notice, a case in 1933, the case of Hall versus Brooklands Odor Racing, the court there said that when you examine the characteristics, when you examine the wrongdoer, you're examining his behavior on the basis of an ordinary person in any particular situation, an abstraction, but it is a man on the Clapham omnibus. So, but we would think that there would probably be distinctions about how a reasonable man as opposed to a reasonable woman may act, right? So anyway, but oftentimes, much of the common law will slide towards a determination of the act by looking at the actions on the basis of the reasonable man. But a more gender neutral way of looking at it would be the actions of a reasonable person. So in other words, because it's based on the actions of a reasonable person, not of the individual who committed the act or omission himself, it is what is known as an objective standard. You don't look at the subjectivity, the peculiarities, and the unique characteristics of an individual who did the act or on the victim, but you look at the reasonable objective person, the behavior of an ordinary person in any particular situation. So you have an abstraction of what you think hypothetically an objective person, a reasonable person would do. Now, because you're basing it on an objective standard, you don't really require prophetic vision that an individual will be able to foresee every single detail of his actions, because no reasonable person can be like that. So the reasonable person standard does not involve the standard of a James Bond. Okay, do you know James Bond? Okay, so moving on. Let's now examine tort law based on its relationship to other areas of law. So we're looking at, from the viewpoint of civil law, for example, the assumption of certain civil obligations. So traditionally, there would be civil obligations, meaning a legal binding obligation on the basis of contract. In that case, if you follow contract law, I, for example, would have certain legal obligations by assuming, certain legal obligations because I enter into it. So when I enter into an agreement, when there are mutual promises between me and another party, the legal obligations I have are on the basis of the mutual undertaking, the mutual agreement that we have. That is based on contract law. So I assume legal obligations. In other words, if I don't assume legal obligations in relation to another party because there is no privative contract between us, then I don't have any legal obligation towards him. There will only be legal obligations on the basis of voluntary promises and mutual undertakings. That is the basis of contract law. Tort is different because the law imposes certain obligations upon an individual to make sure that his actions or omissions do not lead to harm to an individual or property, especially if it involves a legally recognized right. So in tort law, it is not on the basis of me agreeing to be held legally liable for harm, because, so in other words, even if I don't agree, the law will impose on me the legal obligation should I cause harm because of my actions. So it is a duty imposed by law. Now, of course, we know that even as far as contract law is concerned, it is often not the case that it's really on the basis of agreement, because if you follow the Australian consumer law, for example, oftentimes even the manufacturer, so you buy a car such as a Toyota, for example, you buy it from a Toyota dealer. The seller, the privative contract is between the seller and the Toyota dealer. But the Australian consumer law imposes a legal obligation on the manufacturer as well, so that if there is a defect in the car, the buyer can sue both or can proceed both against the Toyota car dealer as well as the manufacturer, even if there is no privative contract between the buyer and the manufacturer. But that's an exceptional case. But traditionally, if you talk about contract law, it's on the basis of a voluntary assumption of legal obligations. In tort, it's not. The law simply imposes a legal obligation on everyone. Following, for example, the case of Donoghue versus Stevenson, that following the neighborly principle, you have to make sure that any of your actions or omissions do not lead to harm or injury to your neighbor. So when you speak of tort law, therefore, there is what is known as a civil wrong. There is a civil wrong because the law says so. So when your act or omission leads to harm to an individual, and there is a legally protected or legal right involved, that is a civil wrong. If you follow tort law, therefore, not only is it a civil wrong, but questions of causation will be determined on the basis of the balance of probability. So when there is an offender or a tortfeasor and a victim, and you're trying to prove causation, who caused what, to what extent did the actions of a tortfeasor cause harm, that is determined based on the rules of evidence of civil law, which is simply a balance of probability. So when you balance the respective evidence of the parties, where does the balance of probability lie? In criminal law, it is different because one, as far as criminal law is concerned, if there is a breach of criminal law, it doesn't just lead to civil damages, it can lead to imprisonment, for example. That doesn't happen that doesn't usually happen when it comes to civil actions. In the case of criminal law, if there is a breach of criminal law, the victim under criminal law is not considered to be the individual who actually suffered harm. The victim is actually the state, which is why we will often see that prosecutions are founded on, it's a case against the queen or the regina and not the individual, because any breach of the criminal law is actually considered to be harm upon the state, even if there is an individual who suffers. Crucially as well, when it is criminal law that is involved, there has to be proof beyond reasonable doubt. it is just a question of balance of probabilities, which is a lower level of standard of evidence when it comes to tort law. Okay, moving on. Let's now examine the aims or theories of tort law. So why, what underpin the idea of tort law? Why is there a tort law? So at a basic level, tort law seeks to compensate an individual who suffers harm. So if an individual suffers harm, he should be compensated. So that is one of the theories of tort law. It provides means of compensating victims of injury and loss. We have to ask sometimes, though, the question about efficiency, and of course, we're going to talk about deterrence as well, because the basic question is, you might have a situation where an individual is walking on the side of a road, and there is this car driven by a 14-year-old youth who stole the vehicle, and injures or kills the innocent individual just walking on the road. But in that case, what if, well, you're dealing with a 14-year-old person who stole a car. What if that person doesn't have the money and that was in a stolen car? You can't hold the owner of the car responsible. Where's the compensation there? So sometimes you examine that it is insufficient to just say that the purpose of is compensation, and which brings us to the issue of insurance later on. So one is compensation. The other one is deterrence. The purpose of tort law in imposing damages upon a tortfeasor or a wrongdoer is to deter that individual from undertaking actions or omissions that can lead to harm. It would be a deterrent. I mean, if I defame another individual, and by doing so, I might be made to pay, $2 million worth of damages, certainly that is a deterrent to me, right? But what if you're somebody who's a multi-millionaire? It could be Elon Musk, or trying to look for the name of an actor. But what if you might be Mark Zuckerberg, a multi-billionaire? He can defame, he might end up defaming an individual, but even if the courts impose a penalty of $1 million, it's nothing to him, or it's nothing to Jeff Bezos, who owns Amazon. So there is a limit to the idea of deterrence. Sometimes it's not enough. The other problem with deterrence is that, assuming that a lawyer provides wrong legal advice, which leads to damage or injury to a client, or even assuming that a medical practitioner ends up harming a patient, will tort law actually be a deterrent to the lawyer or the medical practitioner? But what if there's public liability insurance? So in that case, it's not going to be the medical practitioner or the lawyer who will actually end up paying for the damage. It's going to be the insurance company. The same thing with road accidents, because oftentimes when there is a road accident, especially if there's comprehensive insurance, for example, the driver of the car that caused the accident will not end up paying for the damage. It's going to be shouldered by the insurance company. So to what extent is there deterrence? So these are some of the theories of tort law. Which brings us to the idea of loss spreading and risk allocation. So sometimes the issue really is that tort law should be involved with the notion of trying to spread the loss or allocating the loss. Who is in the best position to bear the costs? And sometimes the way to do it is to impose, to have insurance, because by putting up requirements for insurance, for example, then with a lot of individuals pooling their own resources in the form of premiums to a common fund, and we know that out of that common fund, there might just be 1 out of 1,000 or 1 out of 10,000 cases of tortuous harm, then the loss is spread, and it doesn't become too burdensome for one individual. So that's again a theory of tort law. There is also an economic theory of tort law, whereby the objective really is not to eliminate all laws, but just to deter conduct where the cost of prevention is less than the cost of the damage occurring. So sometimes you simply cannot eliminate all forms of loss. There are just instances where, you know, an activity or a business may potentially cause harm. So if when you think about hot air balloon tours, or bungee jumping, or when there might be river rafting and so on, these are essentially hazardous activities which obviously lead to harm. But should the law then prohibit these activities because they can be harmful and hazardous? The answer is no. Or what if you have a business which ends up making flammable liquid, or harmful chemicals? Should you prohibit their manufacture development because they can lead to harm, or because they can injure workers? The answer is no. What you simply do is to find a way that you simply allow the activity to go on, but you identify who the actors ought to be, who will then have to pay for the damages, as a way of deterring them, or ensuring that they try to have a workplace that will lead to fewer accidents. Another theory is the theory of corrective justice, where the purpose of tort law is simply to assign responsibility for consequences. So the tort law imposes illegal obligation on the part of the wrongdoer to pay for damages, because he was responsible for those actions. But in a sense, if there is contributory negligence on the part of the victim as well, it's all a matter of allocating the cost as a result of the respective liabilities of the individual, both the offender and the victim. It can also be on the basis of retribution, vindication, and punishment. So retribution, it's really there has to be a way that if somebody intentionally seeks to cause me harm, in that case, I should be in a position to, as a matter of vengeance, to get back. And the way to do it would be to know that if I undertake defamatory proceedings against the one who defames me, I can recover damages. So it allows me an opportunity to seek vengeance, or there will be an element of retribution. It can also be vindication, in the sense that by filing a particular tortuous action, I can be vindicated, I can be exonerated. It can also be the form of a punishment. And feminist theory as well looks at the idea that, in a sense, much of law, including tort law, is really kind of heavily leaning towards the idea of a man, a reasonable man. So there is a heavy emphasis on looking at the law from the viewpoint, or from the lens of a man. Masculine. Okay, so as opposed to a woman. And especially for women, women especially know that that can lead to a lot of issues, because men and women are not the same, right? John, I think there was an author, John Gray, who said men are from Mars, women are from Venus. Although I've read part of his book, he does make sense, but I'm not sure if it's scientific enough. But the point there is, it's difficult to deny that there are differences between men and women, the way they think, and so on. And so therefore, if law is always examined from the viewpoint or the perspective of men, it can lead to certain inequalities, or sense of unfairness, and it continues to promote power imbalance in traditional society. And of course, if it's feminist, there is supposed to be a higher ethic of care and concern for all members of society. I'm not really sure if feminists agree with that if you're a woman, you're supposed to exhibit a higher care and concern for all members of society. I'm not sure if women agree with that, but That can be problematic in a sense, some would argue, because that imposes a higher expectation on the part of women that when they act, they have to show a higher level of care and concern. Okay, so there's some inconsistency there. Now, the other point about tort law is that it's really based on the notion of individual responsibility and autonomy. Same thing with a freedom of contract, where individuals, to a great extent, are allowed to get into a contract as much as they like, except for, you can't really contract to become a slave or a sex slave. There are certain limitations imposed by law. But tort law proceeds from the idea that individuals should be granted autonomy to do what they like. The law simply cannot say this can't be done. And to a great extent, therefore, there is a recognition that individuals know about personal responsibility, and that there is a requirement, therefore, that individuals must make sure that they have to protect themselves. So if you're crossing the road, you don't leave it to the driver to make sure that you don't get hurt. You have the personal responsibility that your actions are safe, that your actions don't lead to harm. And so therefore, if a person crosses the road with total disregard for his own safety, and as a result, he is ran over by a car, in that case, some of the civil liability acts will say that the victim cannot have any, will not be awarded any damages because he would be 100% contributorily negligent. Okay, and in the next module, we'll be examining the tort of negligence, which, as I said, is the basis for much of tort law. And we've already covered, in a sense, the interplay of common law, statute, and assurance. Part of the issues will be recognition of new categories of harms, just economic loss and psychiatric harm. We're going to talk more about legislative reforms of 2002 to 2003, which impacted most strongly on the laws of negligence. And as we examine the tort of negligence in Module 2 and in the succeeding weeks, we look at negligence and the tort law of objectives. What exactly, again, was the purpose of tort law? Was it just for the purpose of compensation? Was it retribution, and so on? And so, at the end of this module, you should be able to understand the essence of tort law as a branch of the law of civil obligations, explain the differences between tort, contract law, and criminal law, explain in general terms the basic elements of tortious liability, and finally, explain the aims of tort law within the theoretical frameworks that we discussed. And so with that, I bid you farewell for this video, which provides an introduction to tort law. And I look forward to engaging with you more in our unit. So bye for now.